14. The first order on the agenda is Appeal 2907. I have correspondence from Mr. Brosman, referenced 145 King of Prussia Road. Dear Mr. Ryan, we represent the applicant appellant in the above referenced zoning hearing board application appeal. We request that the hearing on this matter be continued to January 16, 2014, hearing in the Radnor Township Zoning Hearing Board. In order to facilitate this request, applicant appellant hereby grants an extension to the Radnor Township Zoning Hearing Board through and including January 17, 2014, in which to commence a hearing on the applicant appeal, and confirms that the decision of the Radnor Township Zoning Hearing Board will be due within 45 days of the close of hearing on the applicant appeal. Thank you for your prompt attention. This matter, sincerely, George Dozer Brosman. Mr. Brosman?
Yes, good evening. We had received a request from the township solicitor as well as the zoning board solicitor that we consider continuing this because of a change in the membership of the zoning hearing board that is expected when the case might be concluded. So we had submitted this request, and then we asked that you grant this continuance request, and we would proceed at that future date.
Okay. Is everyone okay with the continuance? Okay. The only other thing is there is a group of a good amount of information that the board needs for you to complete the application.
Yeah, we didn't have the exhibits. There's a letter to the zoning officer, there's Mr. Kaczynski's letter back, there's a sketch plan. They were all referred to in the materials. Those were, I think, exhibits B, C, and D. I think A we have. A was deeds, was it?
Yeah. Yes.
Yeah.
Yeah, we had a pile of deeds.
Okay.
I'll tell you what would also be helpful, and I don't know if it's easier for you to assemble this or the township, and that is your application refers to a plethora of prior zoning decisions affecting the property. I don't know if those are handy to be copied or how much trouble it is for us to pull them out. Kevin, are they readily available?
The applicant can, since they're appealing it, can file the appropriate right to know and make the copies of those decisions. Any transcripts would need to go through the court reporter.
I think we may have them, so I'll provide
I'm
them.
just figuring it might be a good idea before the next hearing for all of us to get a chance to read them, because some of them may bear on the issue according to what's being alleged in the application. We want a little time to study all those things.
Yeah, and we need them, ahead of the hearing. I'd love to see them a couple of weeks before so that people can sit down and, at least one of the issues in this appeal, and I'm sure there are others, is does the zoning board variance that was granted, what does it encompass? And is the proposed plan that is covered in the determination letter within or outside what was encompassed in the zoning board, in the prior zoning board approval? But we're not in a position to look at that or get familiar with it. And the hearing is, seeing the stuff for the first time at the hearing is not the way to go on that.
We wouldn't want the folks at home to have to watch us for an hour reading old decisions while the cameras are running, that kind of thing. We could reach a faster decision that way. I'm sure the township has all these things. I just thought it might be trouble if you had to go to different years and pull them out. Whereas
Yes, that is the problem for the
applicant
township
may
to get
already-
that information is in various locations. If
Yeah,
the applicant has those.
He probably does, because he recited them all, so I'm sure you've assembled them somewhere.
If I have them, I believe I do, I'll provide them. I've also requested to see all the files for that property because there was a plan missing that I've asked Biomed for a copy of. They haven't answered me whether they'll give it to me, so I'm going to check. It was the approved land development plan that was mentioned. I'm going to check again in the township files if and when I'm given access to those files. So I'll try to assemble.
George, that was all provided in your
Everything.
previous right to know request.
Yeah, the response, Kevin, was that the land development plan, that the township doesn't have it, and we should get it from Biomed. And I've requested it from Biomed, and I haven't heard back. So I was going to look in the files again to see if it was missed, and I'm waiting to hear back if I can see those files.
George, Nick Healy, who represents Biomed. This is the first I've heard that it was, I thought it was some other plan you were looking for. The land development plan should be in the township files, so, I'll try to locate that
Okay.
for you, but I thought that should be the township file.
To my recollection, it was provided in the right to know request.
Okay, well, I'll double check, but we'll certainly try to get you everything we can, and maybe we can work with Nick and Kevin to get it all
I
as soon as
think
we
it would
can.
help your appeal move a lot smoother if you got this information to the board and
Sure.
its members.
And Kevin, Mr. Cutler said that they were only provided with Exhibit A of our appeal. I assume our appeal, when we filed it, had B, C, and D. Is it missing, or?
I don't know. What you submit to the township is what we forward to the board. So if the board is missing something, it's because it was not in the original submission.
Okay, I'll follow up on that as well.
Okay, thank you.
Thank you.
So if anyone is here for that appeal, 2907, which is, it's continued till January. You can go home and watch us on television, or you can stay. Appeal 2904, which was continued from last month. Applicant Anthony and Gloria Mari, property located at 203 Church Street and Zone R5, seeks a variance and any other required relief from the following: lot area and width 280-35A1, building area 280-35A2, front yard setback 280-35A3, side yard setbacks 280-35A4, rear yard setbacks 280-35A5, impervious coverage 280-35A8, number of off-street parking spaces 280-103B1, parking within front yard setbacks 280-105F, and/or size of parking spaces 280-4B, and any other necessary relief for the construction of the residence.
Thank you.
Yeah.
I'm going to hand up A29, which is a revised plan.
Thank you.
Can I have two? I put one in the record.
Should I, because I know Brad wasn't here, so.
I don't believe you can really have input on this.
Okay. I've marked as A29. Recall last time we talked about modifying the relief and reducing the relief that's being requested. You'll see before you A29, which actually now the plan complies with both building coverage and impervious coverage. So the relief that would be requested, what we've done is we've moved the building up, as you can tell. So the relief that would be requested would be on the front yard setback, the side yard setbacks, and the parking within the front yard setback, because currently you'll recall that this whole area basically parks on the street. And what we've done here is provided garage parking that would fit at least one space, and they can pull in actually into that area as well and have, actually park the two cars, but they would be parked, the one car would be parked within the front yard setback. You'll recall too, and you can see on the plan that that's a deck. The crosshatch portion is actually a deck that is above the first level, but it's no closer than the property existing to the north of it. And you recall that we had extensive testimony last time about the multiple nonconformities in the area as well. I don't know how much of a rehash you want me to go through. You recall that I presented extensive testimony on multiple nonconformities in the area and smaller lots, as well as an abundance of case law indicating that the relief requested here is certainly even less than was requested in these other cases. I know the neighbors are now represented. Mr. Greenfield is here, I believe, representing them. And so I'll reserve presenting other testimony until we hear from Jim.
Do you have any questions? No?
No, I'd like to hear from the neighbor's representative before we go any further, I think.
Nick, did you say you'll conform with the parking sizes too?
The parking sizes, Dan, I don't, I'm not certain, we may need some relief on the length, I don't know.
The length of the width?
Dan
'Cause
Malloy's
it's
already
9
been
foot 8
sworn.
inches. 9'6", right? I think
It's
you need,
9'6" by 20
Right.
is the requirement.
Right, and the house sits back 10 feet from the edge of the road.
okay.
So
And
it's
it's
not-
wide
it's
enough to
not
take,
20.
it's 19 feet wide? I didn't see.
It's, yeah, it's wide, it's a one-car garage.
Okay.
To fit one car.
Okay,
So for the second car, as you know, we need.
right, yes, okay.
Jim Greenfield on behalf of Terry Lindsay, who lives at 201 Church, which is the property immediately to the north of the subject property. This plan is certainly an improvement, but it could be improved still further in the interest of reaching the minimum variances that are necessary in order to enable the reasonable use of the property. So there are two issues that I want to focus on. That's one, and the other is the detriment to Mr. Lindsay as the neighboring property owner to the north. It had been represented at the last hearing, and although I was not here, I have read the transcript, that an 18-foot wide house was the minimum that made any sense in this neighborhood. And I know there was also some discussion about townhouses that existed in the city that might be 10 feet wide. So I undertook to do a little bit of research to see if there are house designs that might be smaller than that are considered to be feasible. And what I would like to do is hand up to the board two exhibits that I have. And I'll mark them N1 and N2, and after I've handed them up, I'll tell you what they are.
These are all the same, right?
Yep. Both of these exhibits are taken from websites from which you can purchase designs for homes. And they're the types of websites where you feed in specifications in terms of what you're looking for in a house, and in some instances, you can even get them to conform to lot limitations, and they will spit out a number of home designs that are available that meet those restrictions. And then, of course, they invite you to pay a fairly significant price to see what the plans are for such houses. If you look at N1, it comes from a website called houseplans.com. And I specifically asked it for homes that were in the range of 12 to 16 feet wide. See if we could come up with anything. And it gave me three designs. The one that I think that I want you to pay special attention to is the one to the right, which is a 14 by 38 foot home. It has 1,033 square feet, 2 beds, 2.5 baths. And that would be compliant, more than compliant with the restrictions that are imposed on both impervious coverage and building coverage. And it has the added advantage of minimizing the variance that would be necessary on the side yard setbacks. As you know, the applicant is now asking for a setback of only 4 feet on each side. If you had, and I should note, by the way, that you have an existing house with Mr. Lindsay living there immediately to the north. Immediately to the south, you have vacant property that's owned by the church. So if this is going to impose a burden on any neighboring property owner, it's going to be a greater burden on Mr. Lindsay than it would be on anyone else. And a house 4 feet from his property line would, in the winter, essentially prevent any light from reaching his house. And that's a significant detriment to have to put up with when you're getting squeezed that tightly. This 14-foot house that you see on N1, 14 foot wide, would, if it were moved within 1 foot of the south property line, enable the applicant to be compliant with the required 10-foot setback to the north, and would give Mr. Lindsay a little bit of breathing room. There would be no reason for the applicant not to accept something like that, and there's no reason to worry about anything going on to the south because that lot has been vacant apparently for more than 100 years. And if you look at Exhibit N2, these are some additional home designs, all of which are, there are 5 of them here, all of them 16 feet wide. I acknowledge that the example at the top, which is a log house, probably does not belong in this neighborhood, but all of the others would appear to be designs that would be suitable for the neighborhood. So it's not only feasible, but it's accepted, and there are designs readily available for homes that are narrower than 18 feet, and in fact, in the 14 to 16 foot range is appropriate. With regard to the law, I found one additional case. Unfortunately, I don't have copies of it because my printer went on the blink today, but I can show it to Mr. Ryan. I can give you the site as well. The case is called Greentowns Financial Corp. v. Zoning Hearing Board of Lower Merion Township. It's a 1993 Commonwealth Court opinion. The site on it is 630 A 2nd 492. And what it stands for more than anything else, it does not diminish the impact of Stefanik, but more than anything else, it stands for the proposition that when you have an impinging physical feature that limits the development, limits the building envelope of a property, and in the Greentowns case, that was a reconfigured floodplain. In that case, the applicant is entitled not to the biggest house that he wants to build, but to a reasonably sized house that accommodates the physical restrictions of the property. So I think that's an important thing to keep in mind here. We have to remember that in Stefanik, you had a lot that was very nearly double the size of what we're talking about here in terms of total area. And a house that was 18.75 feet wide in that case did not take up nearly as much of the property as what's proposed here. So I would respectfully suggest to you that where we want to go with this is to further narrow the size of the house in order to provide some side yard relief to, in order to minimize the variances and provide side yard relief to Mr. Lindsay to the north. And so what we would ask is that you approve a building envelope no more than 14 feet wide, and that you require that the side yard setback to the north be maintained at 10 feet, and that this building envelope be shifted as far to the south as possible, which would give you a 1 foot setback to the south. That's if you're inclined to approve it at all. Any questions I can answer
Questions?
from
No.
the board?
I have a question. Looking at the plan, it has 2 4-foot proposed side yards, and it's got a 25-foot width. So 25 minus 8 should be 17 feet wide, not 18 feet.
No, it is 17.
Right,
It is,
it was-
it's 17 by 41.
It's now 17, in the
Oh, I
original
see it. There it
proposal,
is.
it was 18.
Right.
Okay, so there it is. I see it. Proposed dwelling, outer wall, 17.
Yeah, it says, I think it says clearly on the plan that it's
It's
now
17 by 41.
17
Yes.
by 41 is what I see as well. And again, here, you have this home is being pushed fairly close to the street. And I think, given the dimensions that the applicant now proposes, it's fairly obvious that this home could be shifted more to the rear and not require so severe a variance in the front yard. Again, that's an area where the plan appears to defy the mandate of Stefanik that the variances be the minimum necessary.
Mr. Chairman, I'd be concerned about moving the house closer to the church property without re-advertising it.
I tend to agree to that. Just a question, how wide is Mr. Lindsay's house?
Mr. Lindsay's property?
How wide is his house?
30, the house is 30 feet wide?
30 by what? I'm sorry, 30 by 70? Thank you.
Again, that's a much larger lot.
I understand, I was just for my own information. I'm sorry, did you have a question, Noah?
Is there anyone here who's an official representative of the church in this matter? I don't know if the church has anything to say. And if they're not here, that comes into the advertising issue, because I would think if they were aware of this, they'd want to be here.
Yeah, I think if you push the relief so that basically much more relief is required on the yard abutting the church, I think that you have to re-advertise that.
Yeah, I'm not an advocate of that, only because, just because there hasn't been something there in 100 years, there hasn't been something here in 100 years. So, I mean, that's, who's not to say that some craziness may happen 5 years from now and someone's back in the boat that, why did you do that?
Yeah, but that could be a serious diminishment of the value of the property next door. If the church decides to sell it next month or next year,
Right.
they deserve to be heard before they're deprived possibly of property, right?
Yeah, I agree.
Well, but you know, the other thing to remember is that that lot to the south that's owned by the church is basically a compliant lot. It's more than double the size of the lot that's before you today.
But even
So
so, you're moving, part of that lot, whether it's compliant or less than compliant, is the assumption that setbacks will be observed in conformity with the zoning ordinance on the lot to the north. And they're not going to be on this plan. And if we reduce that compliance down to 1 foot by shifting it over, I think that's got to be re-advertised.
I'm curious as to why you think that, because certainly you've advertised a request for side yard setback variances.
But not to that degree. And that property is not facing, under the present plan, and what was done before was not facing a building 1 foot away from its northern boundary.
Well, I understand, but there's nothing on that piece of ground owned by the church and hasn't been since
But it
this.
could be built tomorrow.
I
built
realize
tomorrow.
that, but still there's going to be a lot more room for whatever is built on that lot than Mr. Lindsay is going to get if this plan is developed as
I'm worried
as set
about a
forth.
Luke v. Cataldi issue.
Right.
And while the courts have been coming back, paring that doctrine back some, it's not one that I would recommend this board horse with.
Well, in any event, we would request that the side yard to Mr. Lindsay's side on the north be at least 8 feet, which would leave you 3 on the south side. That's such a minimal difference from what's been requested that it's.
Again, I'm just talking about I'm not commenting on whether this is the minimum relief or whether what's proposed is the minimum relief, or I'm simply commenting on the advertising issue.
I understand.
Nothing more.
Is it your view that if it's 1 foot difference, that it would need to be re-advertised?
I think there's an argument for that. Look, the trouble with this doctrine is that it is not, it's a sword of Damocles, and how much of a chance are you going to run? Obviously, 3 feet away is less of an intrusion than 1 foot away, my view is that one treads very carefully with that.
Well, again, we think Mr. Lindsay is entitled to some protection here. And if that means that the board would favorably consider giving him a 10-foot side yard on his side, we'd be in favor of having it re-advertised and have to come back next month if we have to.
Again, the only comment that I'm making is that shifting it towards the church property, to me, raises fairly the Luke v. Cataldi re-advertising issue. And I'm not commenting on the rest.
Okay, I understand. Mr. Chairman, the comment that I just made, I don't know if the chair heard or not, but I understand Mr. Ryan's position that it would have to be re-advertised if the proposed structure were moved closer to the church property. If the board is inclined to give Mr. Lindsay protection, and we certainly think he deserves some protection as an existing and longstanding property owner in the neighborhood, that we would be in favor of having the board re-advertise it so that we can come back next month and resolve that issue.
Well, the board will make a decision on that, but thank you
Okay.
for your input. Corey, you have any questions? Nick, do you have any rebuttal or anything you want to add to this?
Very quickly. As has already been pointed out, actually the width of the building has already been reduced to 17 feet. A couple other items, it is very consistent with the rest of the neighborhood as to the side yard setbacks. In fact, you heard testimony last time that Mr. Lindsay, on the other side of his property, his main structure is 3 feet from the property line, and actually his steps are practically right on the property line. So it's consistent with the rest of the neighborhood. Also, as to the light issue, you'll notice that Mr. Lindsay's house actually is 20 feet from the property line. It's not right on the property line as currently exists. And there's been, again, 828, which we presented to the board last time, which included a number of cases, including the Stefanik case. And it is true Stefanik was a larger lot, but in Stefanik, actually, they gave relief for four-foot side yard setbacks, even though it was a larger lot, and permitted a house that was 18 and 3/4 feet wide by 45 feet, despite the fact that it was a larger lot. And finally, the Green Towns case, that dealt with a situation where the setback was only narrowly wide in one portion of the lot. And in fact, the house in the Green Towns case was 2,300 square feet on the first floor. The actual footprint being proposed in the Green Towns was 2,300 square feet, which is obviously, that's at least a 4,600 square foot house. And I'll hand it up to John.
Mr. Keener, can I ask a question? Is there a reason why you didn't move it back to the rear property line?
Impervious coverage. It makes the driveway longer. Yep.
As it's shown now, is that compliant with the impervious coverage
Yes, it
limitations?
is. Mhm. Yeah, unfortunately, the deck counts as impervious in Radnor Township, even though you may have slats underneath it.
Are they pulling under the deck to get to the garage, or is the garage?
Yeah, it's under the deck to get to the garage, but you'll see
But
there's...
the garage
there's
is not
tire-
below the deck. It's back
No,
at the house.
Correct,
Okay.
correct. And you'll see the tire marks, going in. It's not paved. It's just a tire to be able to get in the garage and to park in that area.
Nick, have you had any discussion with the church?
No,
officials?
just last month when they were here, that was the only, times that we've spoken to them.
Church did not represent here.
Yeah, I have not spoken to the church. But it was re-advertised and they received notice.
what is your reaction from the neighbors?
well,
comment?
To
Because
be honest,
the-
we have no problem moving it, but we're not going to continue the case. So if the board wanted to move it closer to the church property, we wouldn't object to it. Certainly, we feel that the width of 17 feet is appropriate and consistent with the neighborhood, but we're not, we will not re-advertise it. We would ask the board to vote on it one way or another. If the board wanted to say that they could move it closer, that would be fine.
Mr. Greenfield, you gave us a plan that showed a 14-foot wide house, but are you saying that 16 would be acceptable?
We think 14 would be more appropriate because it's feasible to build a usable house to enable reasonable use of the property at 14 feet wide.
Would you live in a 14-foot house?
Excuse me?
Oh, that's not the relevant issue, come on.
I
that's
just,
not
I
fair.
Have
think
I ever
14
been in
too
one?
small.
That's not
No, I didn't
fair.
say that.
I've been in many townhouses. We could go back to that
I
discussion.
once lived in a
but
10-foot wide house, so
Yeah.
I can.
it-
You know-
It's out there.
The point is that, you have the garage 9 foot 6 inch. And then where are you going to enter into the house from the front side? So 16 feet and 17 feet, you're asking for 14 feet, it is too tight for
Oh,
any house. They
First
have
of
the
all,
right to build a house there. So that is one reason why we are discussing about the width, how much it can go down.
Well, I understand, but we're only talking about one parking space here. Now, there probably aren't 10%, 5% of the parking spaces in the township that meet the 9'6" by 20-foot standard. But the only place I know of where the parking spaces meet that requirement is the Giant. So if you've got a 14-foot wide house and you've got room, 9 feet 6 wide is more than ample room for one car. That does give you room to get into the house down there.
What about the width of the wall? The width of the wall also to be added into it. So 9.5 for, as you are saying, 9 feet, plus the two sides of the garage.
Well, again,
I
I'm
mean,
tell-
you have to be practical in, demanding 14 feet.
I understand, but I'm telling you that most parking spaces in Radnor Township are probably only about 8 feet wide. So there are very few cars that aren't going to have room for someone to get in and get into the house if you have a 14-foot wide house.
But can we agree to, as Noah said, 16 feet wide and then set?
Yeah, let's just be hypothetical for a second. If we talked about a 16-foot wide house and gave the extra feet of side yard to your client's side so that it was a 5-foot yard, to avoid the issue of changing the deal on the church that may not have shown up because it saw a 4-foot wide yard abutting its property, and now they're going to find out they're going to have a 1 or a 2 foot, and they're going to say, well, I wasn't informed of that, or I would have shown up at the meeting. So if we sidestep the issue of the church and the notice by keeping that at 4, and if they were willing to, and I can't speak for them, if they were willing to knock this down to 16 feet and have 5 feet on that north side, is that something your client would find objectionable or not objectionable?
I can
If you
tell
want
you
to
from,
consult for a second, you can take a few minutes and consult.
if you want, I'll talk to him, but I think I know.
And I'm
the
not, obviously the other side may not agree to this. I'm just throwing it out there.
I'll talk to him for a minute. Thank you.
What do you think about the impervious situation? We should get back. Well, I'm thinking, could it make much difference on their own paving tracks? Could it be so right there? I think to make it 1 foot, because you're putting up 1 foot by 41, so it's big enough. Right, to cover all that? Yeah. Right, yeah. It might not cover it all, but it might, yeah. Right. Yeah, we'll calculate it. I'm sorry? Yeah.
Extend. All I'm saying is if you move that thing closer to the church, you trigger a re-advertising problem. I'm not at all speaking to whether, this is minimum or not.
I took a moment to talk with my client, and Certainly, 16 would be better than 17. We'd appreciate the extra foot over there. But, again, that's not as much breathing room as my client would like to have. Again, you're going to have a tall house. It really is going to impinge on the light that hits him. It's certainly going to diminish the value of his property. But certainly 16 would be, and 5 feet on his side would be an improvement.
Thank you.
Thank you.
Now, Nick, I'm going to play hypothetical with you for a second.
No, I'll go sit down.
No. And you're close to the impervious limit now. You're just under it, I see, if I'm reading this plan correctly. Now, if you knocked, as Charlie just pointed out to me, if you knock a foot off the width of the house, you then can shift the house back so that you don't need relief on the rear yard, because you're only paving those 2 tracks.
But we still
So
have.
you'll pick up the whole length of the house times a foot, and you already have a little bit of margin. So you'll still be within your impervious. You will not need the extra relief with regard to the rear yard. They'll still need it with regard to the front yard, I think.
No, they didn't need any relief for the rear yard anyhow.
The rear yard was compliant.
Oh, that's right, that's right. The idea is to move it back and enlarge the front yard, back to the limits of the 20-foot wide, 20-foot deep rear yard.
Yeah.
And
Now, the problem is, even with 17 feet, when you put in your cinder block and your walls, basically you're talking about a foot on each side already, so now you're talking about a 15-foot wide house anyway, interior. So it's really, really tight, and as I said, the case law and even the homes in the neighborhood call for this wide a house, and I hear the complaints about light, but recall also Mr. Lindsay's house is 20 feet from the property line. So,
is your client's position then that they want us to vote on this plan with no modifications?
yes, please.
Then they don't want to consider a compromise?
I spoke to Mr. Mari, and he already compromised as much as he could. He seriously reduced the size of the home, Noah. I'm sorry.
Anybody else here to be heard on this?
Yeah, anyone else? Why don't you give him the, stay there, just.
I'll give you the mic.
We'll give you the mic, you don't have to get up.
I'm fine, I'm here now.
Okay, you're there now, right? Should have thought of that sooner, sorry.
Right.
But did you swear, did you testify last time, last month? Do it again?
I wasn't here, so just repeat your name again.
My name is John Wallace. I'm one of the deacons at Second Baptist Church.
Spell your last name.
Wallace. John first.
And you're not speaking as a representative of the church, are you?
Yes, I am.
Oh, you have been authorized to speak
Yes, I
on
am.
this matter? Oh, okay, I asked before, and no one identified themselves as being here.
Well,
as a
because you had someone up here speaking at the time, and
Oh, okay,
we don't just,
okay.
I don't know if you want somebody to jump up and,
No, it's fine, go ahead.
okay. First of all, I sympathize with Brother Lindsay's problem, what he has on his side, and he has a lawyer expressing his side of the problem. But to us, there's 2 lots there. There's not one lot, there's 2 lots that are being affected. We bought those lots some years ago with intentions of building another parsonage. We were going to take the existing parsonage, turn it into an office building that we would use for our own use, and put the parsonage over there. So 1-foot setback to us would not be feasible. We haven't had the honor or the respect of the client to come and talk to the church about any of this problem. They haven't contacted us or said anything to us about the problem that they have or what we can do for them or anything. So having a lot with somebody 1 foot away from your lot property line is not a feasible entity in the first place. If we do sell a lot, whoever buys it's that's going to affect that lot. So there's no way that it's feasible to have something like that, as far as the church is concerned.
What was the church's position with regard to a 4-foot side yard setback on that side? Is that acceptable?
Well, none of this is acceptable to us because of that was our lot. It was lost because of the problem that we.
I know, sir, but unfortunately, those days are
Right.
gone, and we have to
Right.
accept it. It is what it is.
So what I can say to you is that 1 foot is not acceptable, 2 foot is not acceptable. You have a law, the laws, you're giving your variances from the laws that you already have for setbacks. So your side yard setbacks are what, 10 feet?
Yes. 10 foot.
And you're asking for a 5 foot, you're asking for 1 foot? 5 foot, 4 foot? You know, we're deviating from the law so much. You're going 50%. You're asking for 50% setback from what you did, what the law states. And that's crazy.
Well, you have to understand that the whole reason for the variance procedure
Well, I understand that.
and for the authority of this board to act is that there's something special about this lot that requires
Right.
that there be relief.
Right, we understand.
Unfortunately, the letter of law doesn't always do justice, so we have to act considering the fairness.
Yeah, but there is certain boundaries that you must take, that you should take anyhow. I mean, to go 50 to 75% of what your original property states for, what if we come in next week and ask for the same thing? What if we want to go 4 foot away from there and build something on it, on the lot, on our lot?
You see, the thing one of the things you have to remember is, unfortunately, and we went over this last month as well.
Yeah, right, sure.
Is that we as a board has to give him some relief to
We
build
understand
a habitable house there that's conducive to what's in the neighborhood.
Right, you explained
If
that.
we won't let him build anything and we stay to what the ordinance reads, okay, and that would be a house, like a 5 foot wide house, 15 foot long, something like that, which is just, that's not reasonable. He, in court law, has said the court will give him the right to build something, okay? And what they may give him the right to build would be greater than what we may give him.
How can it be greater? Because
the court
Because what
might
you're gonna
think,
give him
you know
is-
how the judge could say, hey, you know what? 14-foot house or a 16-foot house or a 17-foot house is too small. In this neighborhood, you can build a 20-foot house. So
but he hasn't had a room to build a 20-foot house.
But you see, the court could say that. So there you're going to have 2.5 foot on each side. All right, so what we have to do is give him the minimum amount of relief so that he can build a house that's comparable to the neighborhood.
Well, just remember that when somebody else comes and wants the same setbacks on that next property, that you should.
Yeah, but each case stands on its own merits. The problem here is this is a buildable lot. It was said to be buildable many years ago when a 20-foot wide property was okay. Okay? Today those standards don't exist. All right? But it's still a buildable lot, so you can't say you can't do something there. It's not like he subdivided it, yesterday and now has come in and wants to do something with it. This is something that's been there for years and years and years and years. So we got to let him
We're
build
not
something
saying
on
that
it.
you can't. We're not saying that you don't have the authority to let him do something with the lot. What we're saying is that you have guidelines to go by, and you're farly exceeding those guidelines.
Mr. Wallace, I think one of the things that is very important to understand is that the body of law that requires us to give him a reasonable use of the property is state law. It outranks a municipality, okay? So in enforcing our ordinance, we have to conform to the requirements of state law, and it depends on the individual property. One property is not a precedent for another. But you've got this lot, this small lot that's existed since 1916, well before there was zoning, and Pennsylvania law says that we have to give them a viable house. And our guidelines are relevant to minimum relief, but frankly, if the only way to give him a reasonable house, which is the ultimate, which is the test here, is to give him a 70% variation or whatever. It's not a test of percents. The test is, what is a reasonable house, and is this the minimum relief necessary to create that? And that directive is coming from a higher authority than Radnor Township. It comes from the state. It comes from the state constitution. It comes from state statute, and it comes from case law by our courts. And we simply have to conform to that, or a court will overturn us. If we don't conform to state law in enforcing our ordinance as to this property, and they decide to take it to court, a judge who's correctly applying the law, if we've screwed up, is not going to let that decision stand.
What rights do the church have, what rights does the church have for those other properties that are infringing on that property? They're going to infringe on our property.
This has nothing to do with it.
Well, we have.
If the church ever wants to do
property
something on
lines.
that property, on the church property,
Right, well,
and if
we have
they
property
need
lines.
zoning relief, we'll deal with it then. We'll look at the facts. It's not the same width as this
So
lot.
in other words, you can give him a variance to go up to 1 foot next to our property. That would be
Well,
lawful.
we could do that, and if
Right.
you were aggrieved, you could take an appeal to court.
Okay,
I mean, the court can overturn us on either side.
okay.
If you enter an appearance and you do the things you have to do to perfect your standing,
Okay,
but we have to find some reasonable compromise
yeah.
that gives them a reasonable use of a residence on that land,
We-
but is not excessive relief under the circumstances. And unfortunately, they're telling us that they want what they've filed now or nothing. So they've basically said it's take it or leave it on that issue. So we're no longer talking about the possibility of coming within a foot of your
I've already
your
advised the
church
board that to go closer than the 4 feet that we were talking about earlier would cause real advertising issues, and that I would not be comfortable with that.
And just to reinforce it, I'm not comfortable with moving it a foot closer. So that's not something that's acceptable to me. And I only have one vote, but that's not something that I would vote for.
Okay. All right, and the only other
'Cause
matter
I think
I
that's
have-
excessive.
Yeah, the only other thing I have is they keep bringing up properties that are in Philadelphia. We're not in Philadelphia. I don't know why they keep bringing those up as examples, because we don't have.
So I keep bringing it up. Let me tell you why I'm doing
But
it.
we don't have 10-foot
I
properties.
can't, but let me tell you why I'm doing it, so I
Go
don't
ahead.
seem irrational to you and anyone else here. One of the standards we have to use is what is a reasonable use of the property for the purposes that are within the zoning. This is zoned for residential use. They want to use it for residential use. What is a reasonably occupiable home? When you're talking about width, I've been in homes that were 100 feet wide, and I've been in homes that were, believe it or not, 8 feet wide. And I actually lived in one once that was 10 feet wide. So we're just trying to say one can occupy a house. This is actually in your favor, because I don't think that one has to have 16 feet to have an occupiable house. It may not give you an occupiable, luxurious 4-bedroom house, but there's nothing that says we have to give them an occupiable 4-bedroom house with 3 bathrooms and a 2-car garage. The question is, where is that standard? And it's a little nebulous, because it's case by case. How small can we make them make it to give approval? How big do they have a right to demand? There isn't a clear-cut formula to use, unfortunately, or fortunately, depending on your position.
Well, we used to call those I'm a little older than I look probably, but we used to call those shotgun houses,
And you're probably from Houston or places like that.
where you walked in the door and you go straight back to.
Yeah, we had houses in Philadelphia they call air lights. Northeast Philadelphia is filled with them. Of course.
Okay.
And the Father,
Well-
Son, and Holy Ghost houses that are one room stacked on another. But yeah, everybody's
Okay,
got
that's fine. If Radnor Township wants those type of houses in their townships, then that's beyond our control.
Well, we don't have a choice
Okay,
here.
Fine.
The question is, do you want it to be bigger? Do you want it to be a nicer home and let it come a foot from the side yard? I'm sure they'd love to be able to build it to within a foot of either side if we could let them, but you don't really want that. You don't want it to be too close to the property line. And yet you seem to want a bigger house for them. So I don't know what to tell you. It's one or the other. It's a
Well,
trade-off.
the thing is, it's not complying with anything that the ordinance says it's supposed to, and you're going so far, you're giving so far much variances for what the law says. That's the only thing I have to say. Thank you very much.
Thank you. Anyone else have anything they want to comment on? Nick, do you have anything else you want to say?
You just want an up or down vote as submitted?
You want to move this exhibit be part of your exhibit?
Before that, I think, Nick, you have to rethink and discuss with your client, because we have come to an agreement with the neighbors, and they said they will accept that 16 feet, and it's, courtesy for you to come to that agreement.
Cora, although we've already reduced it from 18 feet to 17 feet, I've spoken to Mr. Mari, I've sat here and spoken to him, and I'm sorry, I wish that we could come up and say that 16 feet would be acceptable. You can,
love to say something.
come on up.
Chairman, you gave us a bar to reach. All right, we reached that bar. All right, we complied with everything that the board here asked us to do. Now you're setting the bar back again. That's not fair. I mean, this is all about fair. All right. The day my son was born, we were in Wayne looking at houses. All right, but we couldn't afford them. All right. I have my dream. Here we are 27 years later. All right. I'm in the place where I want to be. All right. And this is a shame that I'm so close. I'm a foot away. I would appreciate it if you give me the relief I'm asking for. And I'm just doing what you asked. I mean, it's fair.
We didn't set up dimensions and say, change it to that, and you've got approval conditioned on that.
But
We never set a bar. We
this
just
is all
said,
about-
we rejected what you asked for to start with.
Yes.
We never set a standard and said, you meet that, you're in.
Well, no, I didn't say.
You're
I
making
didn't
it
say
sound
that.
like that's what we did, and we did not do that.
Well,
Be glad
the
to go to the
chairman
transcript
gave-
with
The
you.
chairman, he gave us a goal to reach. We reached that goal.
What goal was that? Define that, tell me what that goal was. And is that reflected in the transcript of the last hearing? What is this goal?
I believe so.
Nick, do you know that we gave?
Last time we were asked to reduce the side yard setback, which we did, and we also were asked to comply with impervious and with building coverage.
But did we
I
give
agree,
you?
there was no.
There were
I
no
agree with you.
dimensions mentioned?
There was no dimensions
No.
mentioned. It was say to reduce the side yard setback. is
I
what
just
we-
don't want you to make us seem like we're going back on our word. That's not what we
Well,
did.
I-
You made an effort. We have to decide whether you've fallen short or whether you've gone far enough. That's what our vote will decide.
I hope this board finds me within compliance.
You're not within compliance. The question is, how far out of compliance will we allow you to be? You are not. You have no prayer of being in compliance with the code. That's not even an issue. Question is, how much relief can you get?
Okay.
Okay.
I'll do this one. Okay. I would vote to give him the relief in the front side and the parking area, and to build the house as to the plans that are set here. I believe that a 17-foot wide house in this neighborhood is the minimum that is compliant with the houses that are there now. I think that anything smaller than that, and I know that some of the neighbors aren't going to agree with this, but I think anything smaller than that would ultimately affect your values of your house downward, because then what you have is a smaller house in the neighborhood, and it's going to bring the values of the other houses down. You need to make sure that what's built there is a house that's going to add to your value and not detract from it.
So you're saying, in your opinion, a 17-foot wide house is the minimum relief necessary to alleviate the hardship?
I'm saying that I vote to accept and give the variances, the necessary variances to build a house to the specifications and drawings that have been on
An A29.
A29.
Is that your motion?
That's my motion.
Chair is making the motion.
I'm making the motion. The chair's going to make the motion.
Anybody
My
seconding the
last
motion?
night will be, I'll do them.
Anybody seconding the motion?
I didn't know we needed seconds.
I have to act as chair, I guess, because you can't second your own motion.
I know.
Is there a second? The motion fails for, huh? The
only
motion
three of
fails
us.
for lack of a second. There is no motion. I would vote, if I have to go up or down on this plan, I would move that we deny the variance relief as submitted through this application and this plan.
It's up to you, Cora.
I would go for that 16 feet width because.
That's not on the table,
It's not
Cora.
on the
You have to
table.
either vote yes or no on the plan, as it
That's
is.
known as the plan.
I will join with the chairman because I don't want the father feeling sad that he cannot have a building in that site with his children. So even with so much reservation, I support chairman's vote for this particular project. Thank you.
Okay, done. Thank you. Applicant 2908. Yeah, I know. 2908, the applicant Academy of Notre Dame Demure, property located at 560 Sproul Road and zoned PI, seeks a variance from section 280-69D and 280-69E relating to setbacks from the streets and side yards. It contends that the relief is permitted as a right pursuant to 280-101 in that the location of the track in the front yard does not increase the existing nonconformity. A variance from section 280-112 relating to the steep slopes, or in the alternative, it contends that the disturbances is permitted under 280-112D5 as a recreation use, or 290-112I as a man-made steep slope, and any other necessary relief for the construction of a sports field and running track. You again.
Evening, yes, me again.
Mr. Chairman, if I just could interrupt for a second, because we're coming up to the next appeal and we need a deed. If there's somebody there from the golf club, we never got their deed, and that ought to be, you know.
Mr. Ryan, I did make the representatives from that applicant aware that we're looking for that, and I believe that they are working on securing that.
Good.
Yeah, Mr. Fromholm had actually told me he was in Tredyffrin and he's coming here, so he could be a little bit delayed.
And he just walked in the door.
Okay, there we go. Okay. This is, now, I know I've marked these because last month we had, there's additional exhibits. You already have exhibits in front of you. Now, A1 to A5. And these are an additional exhibits in addition to what was already presented. Because I remember last month we had some issue with that. So I've marked them. I put on the file A6 to A16. And I'll hand them. These are additional ones in addition to what you already have in your file. I'll give you two.
I need two, and you want for the file. I had to make my last night.
And what I've done also, A6 now is a revised plan to some extent, and the reason it's revised is because we had several discussions with the neighbors, and their concern regarding the track was buffering. So on what's been marked as A6, you'll see the track, and the neighbors requested 3 items. One, there's already woods located on the, I guess it's the northern side of the boundary. They wish that in addition to the woods, that the buffer be closer to the track. So you'll notice, coming down the line, there is an additional buffer that's required by code that comes down and protects those properties on Larchwood Lane. In addition to the buffer, they also requested that, of course, Notre Dame comply with the code regarding the requirements for a buffer area, as I believe as set forth in 280-4 of the code. And thirdly is that the evergreens or the buffer have trees that are 6 to 7 feet tall. And we believe the neighbors are in support of the application, provided those requirements are certainly a condition, and we would agree that they would be imposed as a condition to any approval to this relief the board may grant. Just quickly going over the plan as opening. Most of you, I assume, are familiar with Notre Dame Academy. It's a very tight fit. As you know, their playing fields have been in the front of the school for years now. And actually, we are proposing the same number of playing fields currently. There's 3 playing fields and a softball field. The softball field actually shares one of the playing fields. So we're still proposing 3 playing fields, a softball field, and then a running track. Notre Dame does not have a track on their campus. You'll hear Veronica Harrington, the headmaster at Notre Dame, describe the need for the track. And as I mentioned, we have met with the neighbors a couple times, and their concern was buffer there. So what I would do is first I would call up Ronnie Harrington, and then we'll have Kevin Momedy discuss the plan
Well, a
itself.
little housekeeping first. Is there a landscape plan that's been prepared?
No, there is not.
Because the code requires a landscape plan.
What happens, Noah, is that we'll have to go to Shade Tree Commission, and it's, Shade Tree Commission in Radnor is very difficult, very, I say, tough for developers. And they're going to require certain species of trees, certain types of trees, certain buffering and things of that nature. So that's why we really haven't prepared a landscape plan at this point.
So if we give you approval, we have to condition it upon your
Shade tree
you're
approval.
satisfying them and filing that plan. that
Oh, yeah, we
complies
would have to,
With
yeah.
the zoning code.
Yeah, part of the
See,
grading.
it's also a zoning code requirement. That's why we have to condition
know
the
if-
approval. It's
Yeah, oh, yeah, the
specifically-
buffer is a requirement of the zoning code. And actually, as you read through 280-4, obviously, it's pretty strict requirement they
Yeah,
have there.
that
for the buffer.
71E says a landscaping
Right.
plan shall be required, which shall clearly show in the list of location, size, species, and number of plant material proposed to be used. So that's why I'm saying, since it's in the code itself, we would have,
Yeah, I
if we
don't
grant
know
you
if-
that relief, we'll have to do it subject to compliance with that section.
Because even if we had a landscape plan that you approved.
I know, they would
We'd have
think
to go
of
to
it,
Shade Tree, and they probably would revise it, and then, so I don't know.
That's a form of infinite regress.
Yeah, right, yeah.
Other housekeeping thing is, this plan shows areas of 20% or excess grade, as it's required.
Yeah, and we're going to address that.
But it doesn't show areas in excess of 14 and less than 20, which is also required by the code. It's required that you show both.
Yeah, I don't know if we have, do we have a grading, well, you do have a grading plan. Yeah, differentiation on it. Yeah, because the relief is for anything over 20%, and that's
Yeah,
why
but
we
it-
show it.
But the reason, I'm going to guess why the code requires that be shown on the plan separately and designated separately. And I think the reason is because the amount of 14 to 20% grade may affect how you deal with getting relief on the 20% and overgrade, because it's more steep land, not as steep as to be subject to the restrictions specified elsewhere in the section. But it does require it for a reason. Presumably, there's a reason, and it is a specific requirement of
We
the
have
section.
contours.
Mr. Chairman, if I could add on this issue, this is something that staff and our consultants look at on a routine basis. When projects are submitted as a land development, we review it from that standpoint. Something like this that may not go through land development would be reviewed through the grading permit application process, at which point I look at all zoning compliance and sign off from it, as well as the engineer does. So we make sure that those provisions are met for any process coming in, whether it's landscape buffering or provisions such as showing certain categories of steep slopes. So those are done administratively through the staff as the project moves forward.
Okay, excellent.
So we can ignore that with regard to giving approvals?
It would be conditional on any other requirements within the zoning. It would be conditional on the zoning officer making sure they're compliant with all the ordinances.
Because we can't put our normal provision that says we give approval to construct as shown on this plan, because this plan doesn't meet all the requirements, so this can't be the final plan. See, we have a bit of a hangup because of what it says in the code.
Well, you could then also then condition that, provided the applicant meets all other applicable provisions of the zoning ordinance. And
Which is what we
there's a
do.
variety of other zoning ordinance provisions that would be required that we deal with from the grading permit standpoint that they couldn't show on a plan for lack of clarity. So it's routine when we look at grading permit applications that we go through and we analyze to make sure that the applications, particularly when they don't involve subdivision land development process, are meeting all the applicable provisions of the code.
I'm just concerned because this particular provision affects what we're being asked to grant relief from. In other words, there are many things they're going to have to meet that we're not talking about tonight, all kinds of requirements of all kinds of township ordinances. But this specific one, in this specific section, has a specific requirement that hasn't been met. So it's I think, a bit illogical and difficult to make a decision on a section where there's a requirement that hasn't been met that may affect our decision on the relief requested.
No,
That's-
Well, I would disagree with Nick when he said that our shade tree is tough. I would think that they're thorough, and they do a very good job of
That's what he
making sure-
meant. We all
Yes.
understood that what he was saying
Understood,
was
but
that they're thorough.
We do have other boards and committees that do look at these sorts of things, replacement trees, and incorporating those recommendations into a comprehensive landscape plan, I think is at the appropriate stage through the Shade Tree Commission and not necessarily in front of this board. I think it would be appropriate that this board acknowledge that, recognize it, and if you're so inclined to put conditions that would allow the shade tree to review that in that purview.
Yeah, I don't think you're talking about shade tree. You're talking more about the 14 and 20% grades, right?
Yeah, the first question I asked about the plan was, and the only question I asked about the plan was the fact that the code sections, the section which is an issue in this application specifically says they have to show slopes of 14 to 20, and they have to show them in a way that differentiates them from those that are 20 and above, which they also have to show. So it's supposed to have both on there, and you have to be able to tell one from the other. Technically, under the definition section of our code, only the 20 and above are steep slope, but it doesn't mean a 14 or 15 or 18% grade wouldn't affect how we would grant relief from the restrictions on the 20. That's all. I'm saying that's just a factual issue that might, in some cases, affect our decision or the scope of our decision, the scope of the relief we grant. And without having that information, we have to disregard that issue entirely.
I believe in this application, unless there's other areas I'm not familiar with, but the area in question that remained is steep slopes not created part of a grading permit are being disturbed 100%. Is that correct, Nick? Is that the area inside the track?
It's the hair area inside the track, yes.
So it's not that they're only disturbing a portion of that entire area is going to be regraded.
I see what Noah's saying, though. I mean, it is a requirement of the application. And I'm not fully, I've got my discomfiture with we're supposed to.
Same issue affects the next appeal also.
This doesn't affect, I mean, it has no impact at all on this application, that 14 and 20%.
Well, we're not able to make that judgment.
We have a contour plan. We will present a contour plan, and you can see for yourself if there's anything over or there anything around these steep slopes that are 14 to 20% that would affect your decision.
Do you think I'll be able to tell that from looking at the plan during this hearing?
We have a Pennsylvania engineer present here who can show it to you. He'll be under oath. He can testify as to where the slopes are, and you'll be very able to see that basically this was a drainage area for the building of this garage that's being removed, and the other area is basically a debris area. It has nothing to do with 14 to 20% slopes.
Yeah, but it is a requirement of the plan. I mean, one of the things that this board has struggled with in, the 14 years that I've been with you is the proposition, from many applicants that our, requirements in the code or in our application requirements are burdensome, difficult, pain in the neck, all of that. But they're there because we need them. We're not supposed to be sort of giving vague approvals. They're supposed to be precise approvals. And the pressure is always there to, why do we have to go and comply with an application requirement? And the answer is it's an application requirement.
John, are you uncomfortable with proceeding with this appeal without that?
Yes.
We can testify as to that.
Nick, our solicitor suggests that he's uncomfortable, so you're unfortunately...
May I review, John, the section you're referring to is?
It's
And also-
281.12 sub B. Any applicant for a building permit, preliminary subdivision plan approval, or preliminary land development
Which is
plan
very
approval.
interesting, because we're not here for a building permit, we're not here for preliminary subdivision plan approval, or preliminary land development approval. We are not here for any of those items, and that's when this comes into play, is when you have a land development issue.
Well,
You apply
C
for land
also
development.
says the same thing.
It just says areas of tract containing, it applies to B. John, I respectfully, I totally disagree that we have to have 14, we have to show 14 to 20% here. It specifically states that it's for building permit, preliminary subdivision plan, preliminary land development plan approval. Specifically states, that's what it is. C then
No, but
follows.
C says areas of a tract containing slopes steeper than 14% shall be outlined as follows.
That's correct, but that's following B.
No.
When you
Right.
read- When you're
No.
interpreting an ordinance, you take the most liberal matter as compared to the landowner. It states specifically when you have to do less than 20%, 14 to 20%. Then C says, this is how you shall delineate it
What are you looking
when
at,
it is
281?
14 to 20%.
Oh, the section, yeah.
This is just smoke. I don't understand why this is an issue at all. It's totally smoke.
I think
You're telling us you don't understand why the ordinance required?
It does not require it, Noah. Read
Well-
the ordinance. It
well-
doesn't require it.
I think it does, and so does our solicitor.
John, I asked you to look at it again.
I did. I just looked at it. I think-
Building permit, preliminary subdivision plan.
I
or
think C
preliminary
is
land development.
standalone. I see C as standalone. I'm sorry. I see C, the
How
items.
is it standalone when it says specifically when you're supposed to have 14 to 20%?
I think C is standalone.
You know, and, excuse me, I hate saying this, I've been doing this for so many years, but I have been doing this for so many years, not even going to say how many.
I was
because
doing it
ages
when you were in
myself.
law school.
You were, but I've been doing it here. I know, I agree with you, Noah. I've never had a situation on steep slopes where before a zoning board, I've been requested to have show 14 to 20% slope. Yes, on a land development plan, absolutely, but never
All the
on
plans
a
for
zoning
steep
plan.
slope relief that have come before this board since I've been a member have shown both and distinguished them, every single one. So obviously, we're not the only people that read this way, Nick. Every single one. We've granted relief on at least 2 occasions in the last year or so, and they both showed 14% to 20 and 20 and above.
As I said, I can show a contour plan.
And there's one where we didn't grant
Right.
relief, where they withdrew the application.
Kevin, can,
Now, showing it now doesn't amend the plan that's filed. It's not, it doesn't correct the problem.
We're going to submit it. We're going to submit the plan. We're going to submit the contour plan.
But that doesn't comply with this
Yeah, but it
requirement.
delineates the
Well, I mean,
You have to delineate the slopes and differentiate the one graded from the other.
what are we looking at now?
Well, I haven't, I can hand it up. It was,
This is not in our
yeah,
packet.
I think it is. Let me just see. I believe it's A14. Oh, this is different. I think this is more than A14 now. This is different. This is just I'm sorry, it is not.
What is it?
I can mark it. It'd be A17.
Do we have A17, or is this new?
Kevin, I'll ask you to come on. Well, if you can swear Kevin in.
Do you have A17?
But he's the only copy he has, so I'll ask him to describe it, then I'll hand it up to you.
You raise your right hand, you do solemnly swear or affirm this testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record, please.
It's Kevin Momini, spelled M-O-M-E-N-E-E.
Well, he can see.
I want to ask our solicitor a question. Will this cure the deficiency in the application?
I can't see the thing, frankly, from where I am.
But I mean, if we could, does that cure it? I mean, it's not in the application. Anybody who came to see the application before this hearing to decide if they wanted to appear would not have seen this information.
Nick, you're better off continuing the next month. I mean, you know, if you're leaving yourself open to be appealed by somebody that doesn't want
No
you to
one's
do
going to
it.
appeal it. Everyone's in agreement.
If John's
I'm
okay with it.
looking, I'm just reading it carefully. I read B, I don't see B and C as requiring it to be filed with the application. I do think it has to be part of the record, though. And I think that to the extent that this plan lets the board finds that this plan allows the board to fully understand what it is the board is being asked to do, the board could accept it. But again, I'd like to go back to, the proposition that the requirements of the ordinance and our application requirements are just that, they're requirements. They're not, guidelines to be honored more in the breach than the observance. And we've had this issue many times in the past. And the argument back that it's a nuisance to comply with application requirements is not an argument.
Well, that's not exactly what I'm arguing. I'm arguing that it's not required because it's not a preliminary plan, a building permit plan, or any type of subdivision.
Well, I think C applies, and I think that if the board is able to understand through that, the comparison of this plan and the A6 plan, I guess, the board could decide to accept that. I mean, I'm not in a position, my eyesight's is not good enough to, figure out exactly what's going on up there.
Is it there? It's not there, is it, Kevin? Have you been sworn in, Kevin? Yes. Okay. And does everyone accept Kevin as?
Kevin, your qualification, just you're a registered Pennsylvania engineer?
Yes, I am.
How long have you been practicing?
30 years or
And
more.
you've had your own Momini and Associates for how many years?
30 years.
Okay.
And you've been sworn in as an expert in this township and courts of law and everything?
In other townships, yes.
Okay.
This particular plan is a topographic plan that shows the features and all the contours. In this case, they're 1-foot contours that shows sports fields, the existing driveways. It does show steep slopes, the ones that are 20% and greater. But since we thought that was the only issue that was going to be discussed by the zoning board, we didn't show the other categories of slopes.
Now, just describing the one slope in particular, talking about the slope where it's measured retention basin. Is there any, in that area, is there any 14 to 20% slope?
Nick, if he doesn't have it, we can't accept it.
Yeah, you do have to have the 14 to 20 as well as the in excess of 20.
You need to continue.
I disagree with the whole interpretation that the code is clear on when you have to have 14 to 20%.
We understand your position, Nick. We do, but there's no other reason why the code would require a show of the 14 to 20, except that it could bear on how you deal with the 20 plus, which is steep slope. Otherwise, why would we even care about the 14 to 20?
Because at one time, the code actually, steep slope was 20%, and now it's been moved to 22% in the last 10, 20
But
years.
it changed when they amended this ordinance, adding C, amending C, and as recently as 2000, they didn't make any change in that.
And
It's still required, it always has been.
To me, the inquiry is it's required. If the code requires cherubims and vine leaves up the sides of the plans and nobody brings a challenge to the ordinance, it's an ordinance requirement. This is one that makes sense. This is not silly like cherubim and vine leaves, but we have to proceed with the application requirements. The other thing is I would love to see, if this were continued, somebody writing out precisely the conditions with the neighbors, which, could be shown to the neighbors, and then, assuming the board were to accept this, we could attach as an exhibit, because
We've already confirmed that by email. We could even hand that up if the board desired.
I'd like to see, writing is much easier than you trying to.
The neighbors represented in some way? Do they have an attorney? Do they have a committee? Do they have a?
We've met with several of them. Yeah, they're here. Yeah.
I mean, who wrote? Did they all write the email? Did they? I mean.
I'm sure they
Well, I
got
mean, you're saying it's an
together and-
email. I'm just saying, who's it from?
Yeah, I mean, I would have the neighbors talk tonight so they wouldn't have to come back. Unfortunately, the board's composition will be drastically different next month, so you have to come back anyhow and talk to them anyway, because their opinion might be different than our opinions. Nick, I'm sorry, it's our solicitor's suggestion that we need the 14 and 20 delineated on the plan, so we'll need that at the next hearing. Would you like to continue?
Request continuance.
And you'll grant.
Give the,
I mean, we could talk about the variance on the yards, but since it's going to be a new board, some of us will still be here and some won't.
and I'll give both the time for a hearing and decision within 45 days after.
Conclusion of the hearings. Hey, Nick, just, I know it exists in an email, but if you could bring it written up is something that you can testify has been accepted, because we don't accept emails, for
Yeah, I understand. I
obvious
know you don't
reasons.
accept emails. Yeah, we can do that. I'll see you, Fred. May as well just continue it right now.
You guys may want to listen to me.
We'll take a 5-minute break, if that'd be okay. Are we ready? Are you ready? Yep. Applicant 2909, the applicant, Overbrook Golf Club, property located at 709 Godfrey Road and zoned AC, seeks a variance from sections 280, 112DE to remove vegetation and regrade 560 square feet of man-made steep slopes and construct a golf cart storage building.
Good evening.
Good evening.
Mr. Falcone, members of the board, Fred Fromhold. I'm here this evening as attorney for Overbrook Golf Club. I have multiple exhibit packages to pass out to the board in connection with this application for which Overbrook Golf Club requests a variance from the steep slope provisions of the code. And as you know, steep slopes are defined as slopes in excess of 20%. As had been discussed in the matter that was before you last, there is no regulation of any slopes that are less than 20%. There is a requirement, however, as is noted in the applicable code provision 281.12, that where you have a development plan and in connection with a permit application or a land development plan, that those slopes are to be shown. Now, I have the same issue that Mr. Cornelia had as it relates to his application, and the result of much discussion was that he would have to come back and present plans that show a differentiation between 14% and 20%. And I must say to this board that I couldn't agree more with Mr. Cornelia. And I think the code, as reasonably read, is fairly clear. I don't even think there's an ambiguity that there is no zoning requirement, no requirement that there be a plan presented to this board that must differentiate between 14% and 20% slopes. I think the relevant provision, the only relevance to 14% is found in subsection F of 281.12, where it says, any plan for development of a tract other than a single lot which contains slopes in excess of 14% will be subject to planning commission and approval by the Board of Commissioners. So that even if you don't have 20% slopes, you just have 14% slopes, that is the percentage which triggers review by the Planning Commission and the Board of Commissioners. That's the magic to 14% in the ordinance. But there is no zoning issue.
Mr. Fromo, excuse me. One of our members is recusing him because he's a member of the club and he has to get off the DS.
Thank you.
I'm
Off to
sorry.
the first tee. Thank you. So I don't think there's any relevance in a matter before you to 14%. When a permit plan or a land development application, as noted in subsection F, there is relevance because those plans, whether they have 20% slopes or if they have 14% and 20% slopes, those have to be presented to the Planning Commission and Board of Commissioners so that if a plan is presented to them, in that plan, there must be a differentiation between the 14 and the 20% slopes. Now, in point of fact, our application will require presentation of a land development plan or a land development waiver plan to the Board of Commissioners. It will be reviewed by the Planning Commission. It will be reviewed by the Board of Commissioners. And on that plan, and that plan set, we are required to make that differentiation. And in fact, we would make it. However, in the application before this board, the only relief that we are requesting is to have certain, a very small portion of a proposed golf cart building, very few number of square feet, in a steep slope area, a slope that exceeds 20%. And we are proposing certain grading or earth disturbance in a 20% area. So I believe that when you look at 281.12, which regulates building on slopes, that there is a structure to this section of the ordinance, and it contemplates the differentiation of the 14 and the 20% in those situations where you are applying for a building permit or you have a land development application. At this point, we haven't made an application for a building permit. We've discussed our plan with the zoning officer and with the township engineer. And we have been told that we require a variance where we are doing grading or earth disturbance in excess of 20%. So that's the narrow issue that we're bringing before this board, a request for variance as it relates to a disturbance in slopes over 20%. Now, I feel confident that that is a correct analysis, a reasonable analysis. I'm not unmindful of the discussion that you had about 15 minutes ago as it relates to a similar application.
Okay, I think we have two issues, a deed.
And I do have a deed.
Okay, well,
Yeah,
you need to
and
put that, but,
yeah.
you know, I think that unfortunately, and our solicitor can correct me if I'm wrong, unfortunately, I think that you need to delineate between the 14 and 20% based on 280, 112C. I think that it's quite clear to our solicitor and to our board members that that is a necessity. So unfortunately, you're going to fall under the same.
I mean, Fred, look at it this way. There's nothing in the zoning code that talks about, for instance, how wide a public road must be or anything like that. That's all in Saldo and in the building codes as well. But this is in the zoning code. And if you're asking for relief with regard to steep slopes, we have to be able to consider anything about the property that may impact on our willingness to grant relief and determine the scope of the relief we'll grant. And one of those things is, how steep is the rest of the property? How will it possibly affect something else if this steep slope relief is granted? I realize you're only asking for relief with regard to the steep slope, and that's all the last applicant was asking for, putting aside their issues with yard requirements. The same thing as you, just to change certain areas of steep slope. And we agree it's 20% or more. But yet, this is what's in the code.
Well, Mr. Scott, I submit this, however. This particular section, which is in the zoning code, is replete with references to land development. It talks in the section B, which, as Mr. Cornelia noted, immediately precedes C. It talks about an applicant for a building permit, preliminary subdivision plan approval, or preliminary land development approval. So the code confuses the issue a little bit.
It doesn't say you only have to file it with and at the time of those applications. It just says if you're going to apply for that, this is something you have to do.
There is absolutely nothing that says that. Now, it may be relevant to you.
Why does C make sense? Otherwise, what sense would C make?
Well, C makes.
Why do we care at all about 14 to 20 if we don't restrict it?
C makes sense in this sense, if I submit. You must, where you have slopes in excess of 14%, you need to go under subsection F, if you're looking at subsection F as I am, next to C here. You need then to go to the Planning Commission and the Board of Commissioners, and they have a whole set of criteria. Interestingly, in the zoning ordinance, there's a set of criteria that apply to the commissioners in considering a steep slope development. All of those provisions about the distinction between the two only make any sense when it comes to the commissioners reviewing the plan. Now, I understand your point, and there's a big difference, though, between saying that your application is fundamentally defective if you don't make that differentiation, than with you asking a question as part of a zoning hearing based on a plan that's submitted to you, where do these slopes transition? What are the slopes that are next to the slopes for which you seek relief? So I'm not suggesting that there isn't reasonableness to a question that you might raise in this regard, but I don't think the code requires it as a condition to being considered by this board, that there be that differentiation on the plan presented to you between the 14 and 20%. So I feel good about the argument, but I also realize what you decided in the last application.
Right, kind of affects. You and Mr. Kino are very eloquent in your arguments. Unfortunately,
And you're both very good lawyers and very nice guys, so don't take it the wrong way.
We appreciate it.
But I think that as in the previous case, the stand of this board tonight is the fact that you need to delineate between the 14 and 20. And I would suggest you ask for continuance.
And we accept the judge's ruling, as we must, and we will be back to you, we hope, very soon, and with a plan that differentiates between those.
Do you wish a continuance for longer than January, or will
No, we'd like
January
to,
suffice?
We'd like to be back as soon as possible.
Okay, that would be January 16, would it not?
Yes,
Right.
January 16th.
So
Yes.
if you would give us the extension to commence the hearing on the 16th of January, and then the extension for
We're outta
the
here.
decision from 45
We're outta
days
here.
after the conclusion of the hearings?
We will.
Yeah, okay.
Thank you.
Thank you.
I hear
No
what
further
you're saying,
business?
Mr. Fromhold, but I still believe that C is standalone, and particularly since we're being asked to grant variance relief, I think we need the same information
I
that the
understand,
governing
and-
body and the planning commission would get.
I understand the desire to be consistent in your treatment of these two applications. Mr. Moser, who was a member of the club who was going to offer testimony, is also a member of a zoning board in his municipality, and he wanted me to remind you that if there's any ambiguity, that ought to go in favor of the applicant. And then my response to Mr. Moser was, I don't think it's ambiguous. I
Right.
think Nick Keneally and I are correct on this one, but we understand your ruling, and we'll be back in
Okay,
January.
thank you very much.
Thanks
Very
very
good.
much.
Have a good holiday.
Mr. Fromhold, do you want to leave the deed or just mail it to us? or-
Is that a copy? Is that a copy? I'm going to put that in.
I have it here. and,
Okay, yeah, I'm going to put it in the folder, so they'll have it.
and We'll have the
Great.
additional copies as part of our exhibit.
Okay.
Yeah. And
Well, he's going to, what are you going to read?
Doing great. I will do that. He's coming down actually tomorrow on his way to visit my brother in Texas, so.
Overbrook Golf Club.
yeah, let me,
I think so.
if I may ask one question of the board. As you may know, Overbrook Golf Club is a large property. We have 130 acres. What we have shown in our exhibit package is a site plan that shows the entirety of the property, but we have focused on the development area and the area of disturbance. Is it going to be satisfactory to you that we show the slopes in and about the area of disturbance, the project area, as opposed to slopes and topo for the entire golf club property?
I think that would fulfill our needs. As you say, at the next stage, it might not, but for our purposes, yeah, I think it would.
Okay.
Yeah, I would agree with that.
Good.
Yeah.
Yeah.
Well, I mean, I can't tell you I'll go within 100 feet. It's something that's going to, whatever you would consider, if you were going to decide to grant this relief or not, things that could be impacted by it. Obviously, if there's some 14% grade that's 200 yards away and uphill, it's not really going to affect this. So, I mean, I can't tell you without knowing more about the property, and if I studied the topo map, maybe I could give you some idea, but I think we'll be reasonable in that sense. We just we have nothing at all to look at now.
All right, thank you.
Thank you. Kevin, you have something you want to talk about?
Yes, thank you.
Cora.
Folks?
So if I could have a minute of the board's time this evening, I wanted to come and speak on behalf of my father and Cora, who tonight will end their service to this board in Radnor Township. It has been a pleasure of mine to practice in Radnor Township almost my entire career. And although I've not practiced in front of my father, as a zoning attorney, I've learned much from him and from his wisdom that I have perceived from this board. And it is a pleasure of mine to say that I'm now a zoning lawyer, and I attribute a lot of that to my father and to his wisdom and guidance since I was very young in the area of real estate. So I would be remiss if I weren't here tonight to recognize him and to recognize Cora for their service to this township, because it is it's a labor of love that you all do to sit on a zoning board and give your time to applicants and to attorneys who come and make their case before you. So I'm very proud of my father. It's been a pleasure to serve in front of you, Cora, but I'm very, very proud of my father, and I think that Radnor Township should be grateful for his service. So thank you.
Thank you, Dave.
I'd just like to add, as having been your solicitor for many, many years, it's been an honor to serve with both of you and with Jim, and you'll both be very missed.
Thank you.
My turn. I think Dave stole a little bit of my thunder. On behalf of Community Development Department, the administration here, and the Board of Commissioners, I want to extend our deepest appreciation for the service that you both have provided. Jim as well. Unfortunately, Jim's not here tonight. I want to present each of you a certificate. Again, thank you for all your service to the township. It lots of time goes unsung. It's not an easy position that you put yourselves in, to be criticized for the decisions that you make, but you do make the tough decisions, and we do appreciate it. So again, thank you for all your service.
Thank you so much, Kevin. Thank you, John, and everybody.
On behalf of me, and I'm sure Cora can speak for himself, it's really been kind of an honor to be able to do this over the last, I guess, 14 years. How long have we been here?
17 for me.
17. And Cora especially, because Cora spent,
5
I think,
years.
5 years as an alternate. So for 5 years, he never got the vote. So that's...
No, 3
that's-
votes, 3 times.
So that's truly a labor of love. So, but thank you very much.
And I enjoyed being a member of this elite team, okay? I'm one of those brownies, but, I learned a lot from Peter Bridling, starting from him, and everybody was very polite and tried to teach me how to deal with that. And today, Charlie told me, this is your last chance, you have to defend. Present this case. And my approach is, I don't have to be a lawyer to be a zoning board member. I have to be having that community relationship into my heart. So communities need, I have to take into account before reading through these regulations, okay? Otherwise, they would have had only lawyers here. Okay, we have to reflect the community's feelings. That's why most of the time I ask the opposing team, come up with your ideas. And we even ask for changing their plans to please both sides. Okay, that's the way I think we should represent as board members. Again, thank you all, and Noah, I enjoyed being with you and John. And I had the closest position to the chair. I never occupied that chair because I was scared, how do I handle all these things? Charlie was very nice to me for all these years, and Kathy Bogosian, and everybody. I had always the second seat on the left. So maybe like Jesus was crucified, left side guy was saved.
Let's not get carried away here.
Thank you.
Thank you.